Chicago in the fall of 1980 was a landscape defined by rapid movement and high-stakes corporate maneuvering. Among the city's quiet giants was TransUnion, a highly profitable, diversified holding company anchored by a massive railcar leasing operation. This chart shows the company's core financial contradiction. They generated hundreds of millions in cash flow, but because of accelerated depreciation, they lacked the taxable income required to actually use their accumulating investment tax credits. CEO Jerome Van Gorkom realized that the only permanent way to capture that stranded value was to merge with a company that had enough taxable income to absorb the credits. Acting entirely on his own, Van Gorkom approached corporate takeover specialist Jay Pritzker. He pitched a leveraged buyout at $55 a share, a massive premium over TransUnion's current market price of $38. He structured this deal in private, without consulting his board of directors, his chief financial officer, or any outside financial experts. On Friday, September 19th, Van Gorkom called a special board meeting for noon the following day. No one was told the purpose beforehand. After a brief 20-minute oral presentation by the CEO, the board deliberated for just 2 hours before voting to sell the entire company to Pritzker. They did this without a single written summary of the merger terms. Not one director, including Van Gorkom himself, actually read the agreement before it was signed. Despite the obvious financial windfall of the $55 share price, a group of shareholders filed a class action lawsuit to block the transaction. The plaintiffs did not allege fraud, bad faith, or self-dealing. The directors were seasoned, respected executives who genuinely believed they were acting in the stockholders' best interests. If a board's motives are pure and the sale price is undeniably high, is that enough to satisfy the requirements of corporate law? Delaware law operates on the business judgment rule, a presumption that directors make informed decisions in good faith. To hold a board personally liable, a plaintiff has to prove gross negligence. In his dissenting opinion, Justice McNeilly argued strongly against the negligence claim, viewing the board not as careless actors, but as top-tier corporate professionals. The 5 inside directors alone shared 116 years of combined experience at TransUnion. The outside directors included university chancellors and CEOs of major Chicago corporations, all of whom intimately understood the company's historical tax hurdles. To the dissent, the financial reality spoke for itself. Securing a 48% premium over the market close was an objectively outstanding return for shareholders, one that required immediate action before the offer vanished. Furthermore, the board later amended the agreement to include a market test, intending to leave the door open for competing bidders to offer an even higher price. In the eyes of the dissent, these elite professionals made a fully valid, informed business judgment, perfectly adapted to the realities of a fast-track corporate world. But the majority of the Delaware Supreme Court, led by Justice Horsey, looked past the impressive resumes and the high premium to examine the raw procedural mechanics of the decision. This diagram illustrates what the board failed to uncover. The $55 price tag wasn't derived from an assessment of the company's true value. It was simply the maximum number Van Gorkom calculated Pritzker could pay and still service the debt of a leveraged buyout. Yet no one in that room asked the chief financial officer or an outside investment banker for a formal study to verify if the company as a whole was actually worth more. Instead, they succumbed to a manufactured weekend deadline dictated by the buyer, casting their votes on a legally binding document they had never seen. The majority ruled that elite corporate experience cannot legally substitute for the formal process of gathering available data and verifying facts before making a decision. Recognizing the haste of their initial vote, the board attempted to cure procedural errors by organizing a formal market test to solicit competing bids. The court found this effort legally meaningless. Strict contractual time limits and rules preventing the board from sharing proprietary information with third parties made a genuine public auction impossible. With the market test constrained, the board's final defense rested on the shareholders themselves, who overwhelmingly ratified the deal via a proxy vote. However, those proxy statements lacked complete candor. The board failed to disclose Van Gorkom's role in inventing the price, and they hid the fact that no true valuation study had ever been conducted. An uninformed decision made in September could not be retroactively healed by restricted market tests and incomplete disclosures in January. The Delaware Supreme Court officially reversed the lower chancery decision, ruling that the TransUnion Board was grossly negligent and had breached their fiduciary duty of care. They did not immediately award damages, nor did they legally declare that $55 was definitively a bad price. Instead, the court ordered an evidentiary hearing to mathematically determine the true intrinsic value of TransUnion as of the date of that rushed September meeting. The duty of care in corporate law is an unyielding requirement of process. It is an evaluation of how a decision is made, not a judgment of the final financial outcome. No matter how rich the premium or how experienced the executives in the room, a board violates the law if it fails to critically and deliberately inform itself before striking the gavel.